Thank you. Mr. Chairman, I yield.
Thank you, Ranking Member Langford. Senator Hawley, you are recognized for your questions.
Thank you very much, Mr. Chairman, and thanks to the nominees for being here. Congratulations on your respective nominations. Ms. AliKhan, if I could start with you, I want to pick up where Senator Langford left off just a moment ago and ask you about these lockdown orders that the District of Columbia held were unlawful. Just to follow up on something, did you have any role in the policy of these lockdown orders in terms of creating the lockdown orders?
Thank you, Senator. No, I did not. The Mayor's Office of Legal Counsel passed those orders.
Okay, and did you have any role in the litigation? I see that you weren't formally listed on the briefs, but I just want to be sure, were you involved in the litigation anyway? Can you pull your microphone a little closer to you? I think I'm having trouble hearing you.
Absolutely, Senator. Yes, as with all high-profile litigation, I was aware of it and I was involved. And as Solicitor General, I make a decision of whether or not to take affirmative appeals from adverse decisions. And I think it is a matter of public record and not betraying any client confidences to say that the district did not appeal the preliminary injunctions in the Capitol Hill Baptist case and the companion archdiocese case.
Do you agree with the federal district court's conclusion in that case that the restrictions violated the free exercise of religion?
In light of ethical duties to my clients, I don't think I can comment on whether the district court's opinion, in my view, was correct or not. I can say, as a matter of public record, the District of Columbia did not appeal those preliminary injunctions.
The Supreme Court, the U.S. Supreme Court, similarly struck down restrictive lockdown measures by New York and California in separate cases. Let me ask you this. What do you understand to be the current framework doctrinally for evaluating claims of religious discrimination?
Sure. So, Senator, I think it depends. If we're in the RFRA context, then a neutral law that substantially burdens religion will be subject to strict scrutiny and has to satisfy a compelling government interest and be narrowly tailored to that effect. Outside of the RFRA context, in the cases like Tandon and others that the Supreme Court was considering, they were applying the test set forth in Lukumi, which is that even a facially neutral law can have a burden on religion, and if so, then strict scrutiny is triggered. I think what we learned from Tandon and the other cases, which were the first time the court was able to address the question of how COVID-19 regulations interacted with religious liberty, was that if any secular activity is treated more fairly than a religious activity, that raises the bar and strict scrutiny applies.
So let me come back to the District of Columbia case. Given what the district court found there and its holding, and given what the United States Supreme Court has found in the Brooklyn Diocese case and the South Bay United Pentecostal case and others, what's your? Let me put it to you this way. I mean, do you regard this issue now as settled? These cases as controlling, and you prepared to follow this as precedent established case law?
Thank you, Senator. With the caveat that in the district that RFRA applies, I think, yes, the standard has been set.
Which ought to heighten the protections.
Which is, yes, has heightened protections. But I fully understand that the Lukumi test, which has been reaffirmed time and again from Fulton and then was applied in the context of COVID-19 in Tandon and other cases, absolutely is the framework. It's been the framework, and it's one that I would faithfully apply if I were presented with such a question, if I were fortunate enough to be confirmed.
Well, I appreciate that answer. I've been in the position, or akin to the position that you hold now. I was the Attorney General of my state, so I understand that sometimes, and similarly in my state, I was independently elected, and so the governor and other officers of the state were my clients, and you don't pass the laws. You defend the laws. That's your job, and you don't always get to. In fact, you never get to choose what the laws are. You defend them. So I understand the position that you were in as it regards to your client, and so fair enough. I do want to say, for the record, in light of the Capitol Hill case, the Capitol Baptist case, and the district court's opinion there, I think that what the district attempted to do was very wrong. It was contrary to law. I think that it was unjust. And the district court's opinion, which I've read a number of times now, is very unequivocal. It's very, very strong language. And the idea that you would single out people of faith and say that they can't even meet outdoors if they're masked and they limit their gatherings, but yet other secular, non-religious groups and entities can do that, that's hugely problematic. So it sounds to me like you appreciate that because you recognize the case law that is controlling on this now. And as we've now discussed and I think established, the U.S. Supreme Court has weighed in on this. But I can't let this issue pass without noting that and saying again how deeply, deeply troublesome I find it. And again, I don't blame you for your office for defending the law. That's you're supposed to do that. I'm glad you didn't take an appeal. I think that was the right decision. And hopefully that speaks well about your evaluation of the case. Let me ask you about something different. You were counsel of record, I believe, for an amicus brief on behalf of the District of Columbia and 17 states in the Brnovich case. Do you remember this case? It was on behalf of or in support of the DNC, their position in the Brnovich case.
Yes, Senator.
So that caught my attention because usually, I mean, that case was about Arizona's interest as a state in regulating its own elections, and typically states support other states. D.C.'s not a state, but the D.C. as an entity, along with as its own independent entity, often it stands with other states in supporting federalism concerns. You didn't do that here. I just am curious as to why you felt it was important to lead this effort on behalf of the DNC and the DNC's position, which the Supreme Court rejected. So the court did not agree with your position in the Brnovich case, but just walk me through why you felt it was important to weigh in here against federalism and in favor of uniform federal standards that the Supreme Court ultimately rejected.
Thank you, Senator. The district wanted to provide the experience of states to show that while elections are a matter of state concern, Section 2 of the Voting Rights Act does not impose a substantial burden on them. So we were writing a brief from experience, as many states do, to provide context to the Supreme Court of how a particular law plays out on the ground. The factors that we focused on in the Supreme Court were that it is a fact-specific, context-specific, evidence-specific, totality of the circumstances inquiry, and ultimately the Supreme Court did not rule in favor of the party we were supporting, but they endorsed, in the majority opinion, the totality of the circumstances test. So I see the amicus brief we filed as being consistent with the ultimate holding of the case.
Just my time is just about expired, but can I just ask you, do you think voter ID requirements are illegal?
I have not had occasion to consider that question in my 15 years of appellate practice.
You don't have any opinion on it at all? I mean, it's been much litigated. It was at issue in part in the Brnovich case.
No, Senator, I don't.
Do you think it's unreasonable for states and counties to require a form of voter ID in order to vote?
Senator, I would not want to give the impression that I had prejudged any issue were I fortunate enough to be confirmed. And I can assure you that my personal beliefs have never come into play when I'm considering the advocacy positions of my client or if I were to consider any law that were to come before me.
Well, if that's the case, shouldn't the answer be really easy? Shouldn't the answer be that they're absolutely not illegal given the Crawford case?
Senator, the answer would be that if presented with such a case, I would review the law, including Crawford, and I would apply it faithfully.
So you recognize Crawford as good law and controlling?
Yes, I do.
Okay. I might have some more questions for you on that. I'm sorry, Mr. Howard and Ms. Nodi, that I did not get to you. You probably aren't sorry. But congratulations also on your nominations. I'll have some questions for you for the record. Thank you, Mr. Chairman.
Thank you, Senator Hawley. The nominees have filed responses to